Generally, corporate directors owe a corporation's shareholders a duty of care to exercise independent judgment with respect to the corporation and can't enter into agreements negating this duty. However, such agreements between shareholders of a closed corporation or a company owned by a few individuals may be valid. In the 1980 case Zion v. Kurtz, the New York Court of Appeals considered whether an agreement between shareholders of a closed corporation prohibiting business or activity without a minority shareholder's consent was valid. Harold Kurtz, a securities dealer, sought to acquire Lombard-Wall Incorporated, a government securities firm owned by Equimark. To complete the acquisition, Kurtz formed Lombard-Wall Group and served as the corporation's sole shareholder. Additionally, the group obtained a non-interest-bearing loan from a Swiss bank to provide the $4 million that were needed to purchase Lombard from Equimark. The note was secured via a guarantee from Half Moon Land Corporation, whose principal shareholder was Abraham Zion. Kurtz and Zion then entered into a shareholders agreement for the group that provided that the group wouldn't engage in any business or activities without the consent of the shareholder owning Class A stock. At the time of entering into the agreement, Kurtz and Zion were the only shareholders, with Kurtz holding Class B stock and Zion holding Class A stock. Further, the agreement was to be construed, enforced, and governed under Delaware law. 8 months later, the group and Lombard entered into a separate agreement making the previous non-interest-bearing loan from the Swiss bank bear interest. In addition, the group entered into a separate escrow agreement with Chase Manhattan Bank, in which the group agreed to put money into bonds to secure payment of the bank loan. Zion objected to both agreements, but the agreements were authorized by the group's board of directors. Subsequently, Zion sued Kurtz in state court for declaratory and injunctive relief, seeking, in one of his claims, to annul the interest and escrow agreement for violating the shareholder agreement. In response, Kurtz counterclaimed for reformation, arguing that the shareholder agreement didn't set forth the actual understanding and terms of the parties' agreement. Zion filed a motion for summary judgment on his claim, which the court denied. Zion appealed, and the appellate division reversed. Kurtz then appealed the decision to the New York Court of Appeals.